I don't think I need to keep them, but the one thing I was supposed to give to somebody, but I never did. So I don't think I need to keep them. I just don't want to have to.
All rise. Court resumes. You may be seated.
Okay, this is file 25-24-57-74 FY. We have made this the date and the time scheduled for for arraignment for Ms. Sherry Lee Leek. And Ms. Leek, I'm going to have you stand before the court. Thank you. Ms. Hayes, you represent Ms. Leek, is that correct?
Yes, Your Honor, for purposes of arraignment.
And is that because you have the Public Defender's Office has a conflict?
That is accurate, Your Honor.
All right, so let's go through that process first. You have filled out a public defender form. You are in fact Sherry Leek, is that correct?
Yes.
Can I ask you to speak
Yes.
up a bit? Thank you. And we're going to go through the process of whether or not you qualify for a public defender. You can always hire an attorney of your own choosing, just so you know that. If you wish to hire an attorney, you can certainly do that, but we want to make sure that you have a court-appointed attorney if you do qualify for one. And it appears that you will because you are on Social Security disability, is that correct?
Yes.
All right, then I will grant you one. That automatically qualifies you for a court-appointed attorney. Your court-appointed attorney's information is on your notice to appear with a red stamp as a phone number and the address. Ms. Hayes has been appointed, she is usually appointed through the Public Defender's Office if it appears that there is a conflict. I'm not certain what that conflict would be unless there's a CPS case I'm gathering.
There is, Your Honor. It's our understanding that the Public Defender's Office is appointed to be guardian ad litem for the other child that was in the home at the time and had some previous representation of both the victim in this case and that other child. So that's the conflict.
Previous to this alleged incident?
Yes.
Okay, and so with that then you are appointed a court-appointed attorney. I've indicated to you where to look for that information, okay? Next question. You have the ability to meet with Ms. Hayes prior to today's hearing, is that correct?
Yes.
All right, and I'm sure she went through your advice of rights form with you?
Yes.
All right, and you also signed that advice of rights form that I have here in the file. Did you read that and understand that?
Yes.
Wonderful. All right. You are charged with having on or about November 24, 2025, in the Fruitport Township, County of Muskegon, Michigan, having allegedly committed the offense of manslaughter through the statutory short form, we call it. In that it's alleged you did kill Myla Leek. It is a felony, punishable by 15 years in prison and or a $7,500 fine, DNA to be taken upon arrest. Do you understand the charge and potential penalty?
Yes.
We will certainly enter a not guilty plea at this time. My understanding is Myla is her daughter.
Yes.
That's correct.
All right. So for purposes of bond conditions, we'll get to that, but it was important for the court to understand that relationship. And so you're going to have two hearings coming up in the next 21 days. The first we call a probable cause conference date. The date and time for the probable cause conference date is December 9, 2025 at 1:30 p.m. in the second floor pretrial conference room in the room 215, actually right outside this courtroom, not in the courtroom. Okay. The second hearing is December 16, 2025, 9:30 a.m., right back here, courtroom number 3. I will be the judge on that. So, because it's back here, courtroom 3. This is the only notice you'll receive, so make sure that you hold on to it and appear. We will now get into the issue of bond and any bond conditions that will be required. I'll begin with Chief Trial Attorney for the state, Mr. Roberts, please.
Thank you, Your Honor. First, as it relates to any bond conditions, we will ask the court to impose a no contact order with any minor children, including the other minor child, the other adopted daughter, for the defendant in this case. It's my understanding that Protective Services has already filed a petition to terminate parental rights on that case. The court has already conducted a preliminary examination and suspended any parenting time, so we would ask the court to impose a consistent order with the family court, suspending any parenting time or suspending her ability to have contact with that child and frankly with any minor child if conditions of bond are otherwise met and bond is posted. As it relates to the bond itself, Your Honor, the people feel that a $100,000 bond is appropriate in this case. This is obviously, as the court is aware, a very serious matter and does involve the death of a young child in this case. Certainly this does not appear to be a case where there's any question about who is responsible. At least the evidence in this point has led us to the conclusion that the defendant in this case, by her own admission, did sit on the child, and that appears to have been the cause of death here, although we are still awaiting further confirmation from the medical examiner's office. The autopsy hasn't been conducted, but we have not received those reports yet. But at least to this point, the injuries that were inflicted that caused the death of this child appear to be consistent with the description given to the police by the defendant, in this case, that she sat on this child for a period of time long enough to cause this child to lose consciousness and stop breathing. She was the only adult in the home. The only other person inside the home was the victim's sister, the other adopted daughter, who is medically fragile and certainly was not part of this, it appears, moving forward. So this is a very serious matter, and most importantly, this is a matter which is still under investigation. There are still a lot of reports to be obtained, information from the medical examiner's office, as well as other investigative leads, and we'll be working closely with law enforcement and with Protective Services to see if additional charges are warranted in this case, and certainly at the time that those become appropriate, we will address those with the court. But I think the addition of some more charges, potentially involving at least child abuse charges, are likely to be filed at some point moving forward. Again, so for those reasons, I think just the seriousness of the offense alone, I think a $100,000 bond is appropriate in this case. I'm not aware of any prior history for Ms. Leak, which certainly does weigh in her favor in terms of the court setting bond here, but the court obviously needs to address the public safety issue and the seriousness of the offense issue as it relates to setting bond in this case, and we believe that bond is appropriate at this time.
Thank you. A couple of questions. Sure. How old was this child?
11.
11. And the other child was medically fragile, is that correct?
The other child, my understanding, is the twin sister of the victim and is medically fragile, has some cognitive issues as well, and was certainly not in any way appears to be involved in this. She is actually currently hospitalized, and we're working with Protective Services to find placement for her when she is released from the hospital.
And was this victim, alleged victim, considered medically fragile also?
This victim was not, to my understanding.
And you indicated they were adopted. You say they're twins?
Yes.
Okay. And you indicated they were adopted. Were they adopted through the CPS system?
Yes.
Approximately how long ago was that adoption?
2017, 2018 timeframe.
So several years ago.
Yeah, 7 to 8 years ago.
And it does appear that she does not have a record at all, the alleged victim. It appears that she does not have...
You mean the alleged, not the defendant? You mean?
Yes,
Yeah.
the defendant does not have a criminal history at all.
That's our understanding, yes.
And her age is approximately 55?
Yes.
Is that right?
Yes.
Okay. So 55 with no criminal history, which I would have gathered if she was able to adopt 2 children out of the CPS system, that her criminal history would have been null. So we will turn next to, thank you, I appreciate that, Mr. Roberts. I'll now turn to Ms. Heiss, please, for any comment regarding bonds.
Thank you, Your Honor. While my client has essentially been convicted in the eye of the public, I think at this point, I think it's important to remember that she is still innocent until proven guilty in this case. We understand the nature of the allegations, the seriousness of it. However, as the court and the people have already stated, she has no criminal history, which is significant considering that she is the majority of the way through her life already. I think with the CPS involvement and the parameters that have been put into place with that, I think any potential harm or danger to the community is minimized by that. She is from the Muskegon area. She has lived here her entire life. Due to her not having a criminal history, she also does not have a history of failing to appear. So I would ask the court to consider a much lowered bond than $100,000. I think it's appropriate. I don't think she's a flight risk. If the court is not inclined to do that, I think there's some other parameters that we could put in place that would ensure that she's not a flight risk and could minimize that. Thank you, Your Honor.
Thank you, Ms. Heiss. You may be seated. Thank you. All right. The court has heard the requisite information for determining bond, and this is an incredibly serious matter. It appears that Ms. Leak was the only adult in the household at the time, and it appears that the injuries that caused her death are very consistent with something that would probably not be accidental or medically related to the victim herself. And so for those reasons, I do find, and there is also the fact that the defendant does not have a criminal history, but with that, we're not quite sure how she would react to an offense of this severity. So whether she would return or not, I don't know. So given all of that, the court is going to go ahead and make bond conditions of absolutely no contact with any minor children at all. No alcohol, no non-prescribed drugs, no marijuana, no new charges, unless, again, any medically prescribed medication is just fine. But outside of that, I want to make sure that you're living a sober life and that you don't end up into a situation that can interfere with your appearance in court or anything to that effect. So those are the bond conditions. Your bond itself will be a $100,000 cash surety bond. Frankly, I thought to make an even higher bond for this type of case, but given the prosecutor's position, again, given the fact that you have no criminal history, that will be the amount of the bond. So, you're all set. Unless there's anything further.
No, thank you.
No, Your Honor. Thank you.
Sure. Yeah, what is that? I was just going to say, wait. further discussions and so forth.